Well, welcome back to the second segment of my interview with Brittany from Best Coast State Law. And if you've missed the first interview, please feel free to check out the link in the content part and watch part one of this great conversation that I'm having with her. So, here I have a question because one of the concerns I think of people when they want to create a trust is they feel they will lose control over their assets.
Yes.
How will that go?
Yes, I get this question a lot, and I think it's helpful to explain a trust. And well, let's use you as an example.
Okay.
If you create your trust, there are three parties in Armina's trust. Armina is all three parties as long as you are living and as long as you have legal capacity. You are the trustor or the grantor. That just means you created the trust. You are the trustee. That means you have legal control. You can sell your home, you can lease your home, you can refinance your home, all in the name of the trust because you're the trustee. And finally, you are the beneficiary. During your life, you benefit from the assets in your trust. Okay, so because you retain that legal control and that beneficial interest, the government says this is a disregarded entity. We cannot tax it. It is just an extension of Armina as an individual. Okay, so during your life, you lose no control. The true benefits of a revocable trust are when you are no longer living. It won't change anything about how you manage your assets during your life. It will simply ensure that your loved ones avoid probate court after you pass away.
Okay, great, because I think that's the biggest fear that people have.
Absolutely.
Which brings me to my next question that I think is very important, and that's power of attorneys.
Yes.
We've seen clients come in, they're in another country, they're in another state, and they can't do anything. So it's always good to have a power of attorney, but there are different types of power of attorneys. So can you please explain those?
Sure. So a power of attorney accomplishes what we refer to as incapacity planning. So if you are living, but for some reason unable to manage your affairs, you need both a financial power of attorney and an advance healthcare directive, which is sometimes called like a medical power of attorney. Same idea. Okay, the difference between the two is that your financial power of attorney can step into your shoes for you and manage financial affairs, pay your bills, file your taxes. Whereas your healthcare agent, your medical power of attorney, works with your physician to make sure that you're receiving the treatment that you need. You might name the same person in both roles, but you don't need to. And so the state of California separates those jobs and says you have a financial power of attorney and a medical power of attorney.
So my medical directive that I create
Yes.
names somebody to make those decisions of me being on life support or not is named in that directive.
Exactly right.
And I have expressed my wishes as how I want that scenario to be handled so they don't feel guilty or bad about.
Yes, exactly right. And what I tell people with all of the documents is that the name of the game in estate planning is what's our backup plan? So perhaps you have a partner who is the obvious first choice to step in and make medical decisions for you. What if your partner's unable for some reason? I want a second choice for you, if not even a third, so that we have protected you no matter what the future circumstances might be.
Okay. And that made me think about, please talk about the guardianship
Yes.
and
yes.
the children.
Absolutely.
Because that's so important.
Yes, I'm a mom. I have a young daughter, and guardianship, I know, gives every parent of minor children peace of mind. So in California, in your will, you will name who you would want to take custody of your child. God forbid, neither of the child's parents were able to take care of them prior to reaching age 18. This is another place where we like to put several options. Sometimes people would like to put conditions on those options. You know, perhaps your brother is the right person to serve as your child's guardian because he lives down the street. But if he moves to New York City, he's no longer the right person to be your child's guardian. So we can put all sorts of conditions like that. And I know that naming a guardian always gives our clients with young children peace of mind.
Yeah. It's a very important decision and step that every parent has to take.
Yes.
Well, Brittany, I cannot say how grateful I am to have you here.
Thank you.
This was an awesome conversation. And again, please feel free to touch base with Brittany for all your state law planning questions or concerns. For all your real estates, please feel free to give me a call back. As you know, I specialize in senior real estate. I've helped a lot of seniors and their families to sell and buy properties, etc. And we are here along with my other professional partners to answer any questions you may have. Until next time, see you. Have a great day.